Hi everyone, I hope that all of you are safe and doing good. Through this audio, I will be looking at one of the most heated topics in the country. That is, none other than the amendment suggested to the 19th Constitution of Sri Lanka, or in other words, the Gazette of the 20th Amendment. This Gazette that is published to the general public should be gazetted for 14 days before it is placed on the order paper, and the 14 days would start its count from 3rd September 2020. In observing the amendments, it is clear that the 19th Amendment is not completely abolished. Instead, certain provisions are amended while some others were introduced. Accordingly, in considering about the presidential powers, it is observed that the president is given 100% immunity while no civil or criminal lawsuits are possible against the president. Moving on to the Constitutional Council and its role, the Constitutional Council, according to the 19th Amendment, was given substantial powers in appointing individuals to the high ranks like the Attorney General, Inspector General of Police, Chief Justice, members of the judiciary of both Supreme Court and Court of Appeal, along with the appointments done to the independent commissions like the Elections Commission, Audit Commission. This council, according to the 20th Amendment, is completely abolished, and instead it is renamed as the Parliamentary Council. Therefore, the newly proposed Parliamentary Council and its members will be appointed along with the nominees of the Prime Minister, the Leader of the House, and the Opposition Leader. In addition to this, the nominee of the President and the 3 other members of the civil society who were serving in the Constitutional Council as per the 19th Amendment will no longer be serving under the 20th Amendment. This means that the Parliamentary Council this time around will not have members from the civil society. In comparing the Parliamentary Council with the Constitutional Council, we see that the Parliamentary Council does not exercise any substantial powers. Instead, it only exercises an observatory power. These observatory powers are regarding the appointments to high position only at the discretion of the President. Therefore, through this amendment, we once again see that the President had regained the power in appointing individuals to superior positions as existed under the 18th Amendment. In discussing about the appointment to the high post, for a long time period, there was a controversial issue regarding the appointment of the Inspector General of Police, and even currently we have an acting Inspector General of Police. This problem is resolved by the 20th Amendment by allowing the President to appoint the officers to the National Police Commission, who in turn would appoint the Inspector General of Police. Therefore, now there is no necessity in obtaining the Constitutional Council's approval to change the position of the Inspector General of Police. In considering about the transitional provisions or the transitional powers, the following commissions are allowed to hold on to their positions and continue as usual. They are the Elections Commission, Public Service Commission, National Police Commission, Human Rights Commission, Commission to Investigate Bribery and Corruption, the Financial Commission, and the Delimitation Commission. However, the National Procurement Commission and the National Audit Commission were abolished. by the 20th Amendment to the Constitution. All these shows that the President can appoint the Chief Justice, the judges of the Supreme Court, the Chairman of the Court of Appeal, the judges of the Court of Appeal, members of the Judicial Service Commission. In so appointing, the Parliamentary Council will merely provide observations at the discretion of the President. In addition to the appointments, the 20th Amendment to the Constitution allows the President even to appoint the Attorney General, Parliamentary Commissioner for Administration, who is also known as the Ombudsman, the Secretary General of Parliament. Having said about the powers and functions of the President, the 20th Amendment had also considered about another heated debate. That is about the possibility of the President to hold ministerial portfolios. According to the 20th Amendment, yes, the President can hold on to any ministerial portfolio, and the President can appoint any number of both cabinet and non-cabinet ministers, including deputy and state ministers. The President can also assign any portfolio to any minister, where the Prime Minister only can provide observations on these appointments. The next amended provision is that the President can dissolve the Parliament within 1 year of the appointment of the Parliament. Therefore, now there is no need to stay for 4.5 years to dissolve the Parliament. Further, in considering about the age limit in contesting to the presidential election, up until now, according to the 19th Amendment, you have to stay till 35 years. But the 20th Amendment to the Constitution had reduced the age limit to 30 years, and anyone above 30 years is allowed to contest to the biggest election. The issue on whether a dual citizen could hold a ministerial post was also addressed by the 20th Amendment. According to the amendment, even a dual citizen is entitled to hold a seat in the Parliament. So, let's wait and watch